proceedings regarding the verified motion to modify custody. Court will first make the observation this is the first setting in regards to this motion. The court has reviewed the motion, finds that it's properly verified, and does colorably state a prima facie case, which warrants this court taking further action in regards to this motion. Ms. Martin, are you opposing the relief sought in this motion filed by Henry?
For overnight, yes.
Okay.
I'm totally okay with him getting parenting time a few hours throughout the week and a few days.
Okay, you say that. Okay, let me stop you there. You've read the allegations in this motion, and Henry says that he hasn't had parenting time since December, if I recall. Why is that?
Because one night I was asking, he had her all day, and I asked him to call me after her.
Buckle up, guys. Right out of the gate, this custody dispute shows the emotional tension between two parents who clearly don't trust each other. The mother argues she's simply protecting her child's comfort, claiming the toddler isn't ready for overnight visits. But the judge quickly spots the bigger issue. When one parent blocks contact for weeks, that separation itself can create the very discomfort being used as justification. It's a classic cycle in custody battles. Distance breeds hesitation, and hesitation becomes an excuse for more distance.
Nap. He did not contact me all day, and he'd already had her the day prior to as well. And I was just wanting to get in contact with my child and seeing how she was doing. And then it came into a whole argument that he wouldn't let me contact her, he wouldn't let me see her because he was too afraid that she'd want to come home if she's seen her mom. And so then I said, well, if you're not going to pick up the phone, then I'm going to show up and I'm going to take her home with me. And then he made me have to call the police to be able to even see her. So, and to get her back into my custody. So since then, the cop told him that unless there was a court order in place, that he could keep her for as long as he wanted. And I'm not okay with that because I'm the one who's been raising her for 3 years all by myself. He's been in and out of her life.
Okay, and the little girl is 3 now?
Yes.
Okay. I trust, Mr. Blanchard, that your client is still pursuing the relief sought in his motion for this court to adopt a new parenting plan?
That is correct, Your Honor, and I'd like to have the opportunity to argue if the court will allow it.
You may.
Okay. Your Honor, we dispute much of what Ms. Martin has already stated. My client said that whenever...
All right, guys. Now the story behind the conflict starts unfolding. The mother says everything spiraled after one day when the father stopped answering calls while the child was with him. To her, that silence meant something was wrong, so she involved police just to see her daughter. But from another angle, this begins to look less like concern and more like a breakdown in trust and communication between the parents.
Has a child in that particular weekend, which would have been the weekend covering December 20th, that she was blowing up his phone with text messages and phone calls, and finally it was interfering with his opportunity to have meaningful contact with his child, and he just stopped responding and stopped taking her calls because it was just relentless. And then she's the one who called the police and came over to do a welfare check. And my client, as I stated in my motion, he complied with the police officer's request. He brought the child out. The police officer noted there was no problems with the child. The child did go to see the mother, and then the mother wouldn't let him have the child back, even though there was an agreement that he would have the weekend and the overnight. And they had actually modified the existing parenting plan where he was starting to have more time with the child, including weekends. And then when he said, I want my child back, the police officer said, do you have a court order which gives you overnights? And he said, no, I do not. So he said, I don't have any authority. This is a civil matter. Bring this matter to court. So that's where we are now. Then from and after December 20th, he's had no contact whatsoever. Ms. Martin has said over and over again that she is the sole parent in this matter, that what she says goes. I have attached several exhibits.
Here's where the father's attorney steps in and reframes the entire narrative. According to him, the phone calls weren't simple check-ins. They were constant interruptions that prevented the father from spending meaningful time with his daughter. And when police arrived, they reportedly found nothing wrong. From that moment forward, the case shifts from a misunderstanding into a legal dispute about parental control and boundaries.
Exhibits in which she states that same thing and saying she doesn't care what he says, she makes the determination. My client said that he has worked hard to have a relationship with his child, that his parents are here and they have a relationship with the child. And to be cut off from this child for 77 days now has been extraordinarily difficult. I don't want to go through point by point my motion because the court has already read it, or point by point with regard to my exhibits. But I would point out that one of the things we stated in our motion is that Ms. Martin has a habit of smoking marijuana consistently. In my Exhibit 8, she talks about her purchase of marijuana, when she has a text message with my client. We certainly ask that she be required to submit to a hair follicle drug test today at our cost. Let us know where it would be done in El Dorado, and our firm credit card will pay the cost. If the court wants my client to submit to a hair follicle drug test, he will do the same thing at his cost. We've asked for some pretty serious changes in the custody arrangement. We've asked that he be designated as the primary residential custodian, and we think that's appropriate under the circumstances. I point out in my motion the fact that she has violated virtually everything in the temporary parenting order about how you parent a child together. And then under the statute 233203, I point out 7 or 8 issues where it certainly favors my client. The rest are neutral or not applicable. He wants to be involved in his child's life. I put first, we want him to be the primary residential custodian and giving her regular parenting time. The second thing is, although it'd be difficult in the circumstances, he would work his best to do a shared residential custody arrangement, but that implies that both parties are able to work together. We think that she has not been willing to work with him, and with that in mind.
Now the stakes rise dramatically. The father's side claims the mother not only blocked contact for more than 2 months, but also repeatedly declared herself the only decision maker. That's a serious allegation in family court because custody law generally assumes both parents should play active roles. To strengthen their case, they even raise issues about marijuana use and request drug testing, an aggressive legal move designed to question the mother's judgment.
That would, I think, support more him having primary residential custody and her having a regular parenting schedule, which we have proposed to be every Wednesday from after work till 7:30 or 8, and then on the weekends that she have every other Friday from 5 or 6 until Sunday at 5 or 6, and follow the holiday schedule that was in place in the original parenting plan. We think there's a strong basis, Your Honor, for the court to honor our request at this time, and that's what we're asking. And at the very minimum, that the court would order a regular parenting schedule, which is our exhibit. It's our exhibit 4.
Which is alternative mom primary. Is that the one you're referring to?
Well, the last one is, and it's just because we want regular parenting time that she would be primary, although we don't think she deserves it, but anything to get him started to have meaningful contact with his child. And that's the last gasp that we'd have, but we do think that we've justified a reason for changing custody in our motion and arguments today.
All right. Ms. Martin, I'm sure you're familiar with the proposed permanent parenting plan, alternative mom primary. What's wrong with that plan?
Me being alternative or me being primary?
You being...
At this stage, the judge focuses on practicality rather than accusations. Instead of diving deep into every claim, the court wants a structured parenting plan that restores consistent contact between father and child. The proposed schedule isn't unusual at all. Midweek visits and alternating weekends. What the judge is really testing here is whether the mother objects because of safety concerns or simply because she doesn't want to share control.
Primary, but it sets forth, I think, a rather structured and actually a fairly common parenting time schedule for the father. Are you just saying that he shouldn't have the child overnights ever?
Not until she's old enough, like a little bit older. She screams and cries even when he comes to pick her up just for a few hours. She doesn't want to unlatch from me.
Okay.
I feel like she's not comfortable enough to stay overnight. She's been with me for 3.
Of course, keeping the child from the father for over 70 days, doesn't that help contribute to some of that? Deprivation of the relationship between father and child, you don't think that has a negative effect on the child's willingness to go see her dad?
No, because before I was allowing him to have a lot more than even what we had scheduled. I was allowing them to have a lot of time, and she was still doing it.
Okay, now I'm going to go back to Mr. Blanchard for a moment. Mr. Blanchard, tell me about your client's household. What environment does this child go into when she goes to visit her dad?
Okay, my client has a significant other, a fiance who's a very good person. She's about to have their child together. There's a 2-bedroom house. The child of the parties has her own bedroom. The new baby will be in a bassinet.
And here comes the core disagreement. The mother says overnight visits shouldn't happen yet because the child cries and clings to her. But the judge points out a powerful counterpoint. If the father hasn't seen his child for over 70 days, of course, the relationship will feel distant. Limiting contact may unintentionally deepen that problem rather than solve it.
In their room for a period of time. In her living arrangement, as I put out in my motion, she has 6 people living in the house, and the child sleeps in the room with her and sleeps in a bed with her. We would also dispute her allegations that the child screams and doesn't want to go with the father. That's not my client's experience, nor is it the experience of the grandparents who are here or his significant other who is also here. And if we went to an evidentiary hearing, all these people would testify as to a good relationship with the child when he's allowed to have contact with the child.
All right. Thank you for that additional information, Mr. Blanchard. What is apparent to the court is that the parents aren't working well together to share parenting time and parenting rights involving this child. The court generally is fairly protective of newborns, small infants. The court is always trying to be cognizant of who's qualified to really raise children of that age. But this child's toddler age. She's 3. And I'm sure she's a handful at times, as 3-year-olds are. Mr. Matlock, are you really in a position to handle as much parenting time that's on your schedule, which is a full weekend at a time and every Wednesday night?
Yes, we've actually done it for longer. It's usually a Wednesday and a Friday every week, and then we get some weekends. Whenever we have her, we have no problem with her. She's well behaved. We get her in bed at a reasonable time, 9 or...
The father's attorney then paints a picture of stability in the father's home. A 2-bedroom house, a dedicated room for the child, and support from grandparents and a partner. Meanwhile, he contrasts that with the mother's crowded living situation. Whether those details truly matter or not, the strategy is clear. Demonstrate that the father's home is just as capable of providing a stable environment.
9:30, and she's up the next morning at 7 or 8. We have breakfast, lunch, and dinner. Kendall's got educational games on her phone that help her with her speech and pronunciation that she actually really liked. We have no problem with her keeping her entertained and eating healthy meals and just keeping her.
All right, Mr. Matlock, what about this claim that the child has real adjustment problems for several hours after going from the mother's home to yours?
In the beginning, yeah, it was a bit of a struggle to get her used to sleeping over at my house, but by the third night that we had her, not third night in a row, but just third night in general, she was having no problem going to sleep. She doesn't have any problems going to sleep. I could tell her to go to bed and she'd fall asleep right there. We do. I'll read her a couple of books that we have. She likes to read Dr. Seuss, Green Eggs and Ham, and we got a couple of Bluey books that she likes me to read to her. After that, she's out cold the whole night. No problem.
Okay. I expect straight answers on this, Mr. Matlock. Are you currently on probation for any offense?
No.
Do you have any criminal cases pending?
I do not.
Mrs. Martin, I'll ask you the same questions. Are you currently on probation for any offense?
No.
Do you have any criminal cases pending?
No, Your Honor.
Okay.
Now the judge turns directly to the father with a practical question. Can he actually handle regular parenting time? The father confidently says yes, and even describes bedtime routines, books they read together, and daily structure. It's a small moment, but powerful, because courts often look for exactly these kinds of details to measure how involved a parent really is.
Again, it's apparent to the court that the court is going to need to set up a structured parenting plan for these parties to follow. And I'll warn both parties that if the court makes this order for specific times, I will expect both of you to follow it to the letter. If you can't agree on variations, which is a shame, and I think that's tragic, because special circumstances will come up from time to time. But I would really hope that you two can learn to work together to be a little bit more flexible. But the court, I think at this point, needs to set a rigid schedule. At least at this point, the court will implement the proposed permanent parenting plan, though I'll call it a temporary parenting plan. Alternative mom primary, which was filed in the case. I don't see an exhibit number on it as far as the court file is concerned, but it's the proposal which calls for the father to have parenting time every other weekend, from Friday at 6 p.m. to Sunday at 6 p.m., every Wednesday from 5 o'clock p.m. to 7:30 p.m., and any other time that the parties mutually agree upon in writing, which I don't have any real optimism is going to happen until you two develop some sort of cooperation and rapport with one another. But I do want to set forth that every other weekend and every Wednesday night schedule. I think this child needs to get reacclimated to the father in the father's home. And I find it tragic that there's been a long deprivation period here because the court believes that the Wednesday night should be the first visit rather than an overnight. Next Wednesday will be the start of this parenting plan. I trust starting your weekend, not this weekend, Mr. Matlock, but the weekend after, is consistent with your schedule?
Yes.
So yes.
Okay. So the mother will have this upcoming weekend, and then you would have the one after that on the every other weekend rotation. That gives you the Wednesday night to kind of get reacclimated with your daughter. There may be a little bit of transition problem there at first. She hasn't seen you for a while. I'm sure that after a couple hours, she'll get reacclimated and she'll be in a better position.
And finally, the court steps in to impose order where cooperation has clearly failed. The judge establishes a structured parenting schedule, Wednesday evening visits and alternating weekends, giving the child time to rebuild a relationship with her father. It's a reminder that family courts prioritize consistent contact whenever possible. If you enjoyed the breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next video.